They say journalistic reasons. The Act talks about fair and accurate reporting. They'll say all of those cases, it's perfectly fine for someone to wave the flag, and they are exercising their rights as they're entitled to. The question is, what's the countervailing right? To say that someone has a right not to be exposed to someone else's hate speech. That would be one of the questions that has to be determined. It might be that you're entitled to punish someone who has acted in accordance without having the right to do so, but that must be done on the facts of the case.
No, but was the countervailing rights not determined both in Polani and in this case? In other words, whether there was an infringement of Section 10 in this case, and particularly the right to freedom of expression of Section 16. I mean, didn't the court determine that? And determine that not in the abstract, but based on a certain set of facts, and to regulate conduct for the future. That's what the declaratory order seems to be relates to existing future or contingent right. and if one takes into account the purpose of the Equality Act, then surely the court was entitled to make the declaratory order so that it is in this case.
Well, Justice, it seems astounding that an order could be made in the absence of one of the parties. In other words, with regards to the first order that is made, the declaratory is made about a particular instance where the parties to that instance played no role in the litigation whatsoever. And the example that I've given before is with regards to the burning of the South African flag, that if we hear the ex parte version and we hear the RD ultra partem version, we would have different pronouncements as to whether it amounts to hate speech. So to declare something of that significance in the absence of the party who is involved, I cannot think of another instance. I cannot think of any instance in the case law where that happens. And the second case is not, in other words, in Polani what happens is that the court says other parties should be guided by this case. In other words, those that were to write articles similar to John Polani's now have an indication that their articles might amount to hate speech. But it's not more concrete than that. There's no banning of a particular word to say that you cannot say this phrase, you cannot utter this idea. But there is a signal that is sent out, which is that this counts, and so guide your conduct accordingly. And that has the kinds of deterrence effect that many particular findings will make. But that's very different from an abstract finding that all instances of the use of this word or of this symbol will necessarily amount to hate speech. Now, the appellant's case is that in order for something to amount to hate speech, it must meet the test set out by Polani, which in other words, it must amount to the promotion of hatred on a listed ground, and then it can be either inciting harm or that the words themselves are harmful. And we know that harmful is a much higher threshold than hurtful. But it means that every single instance must meet that test. And if there is an instance of flag waving that doesn't meet one of those requirements, then we know that there's a problem, that there's been a ban for conduct that is not unlawful. Now, the particular examples that are provided try and demonstrate this. So, we can imagine the anti-apartheid protest case. We have a group of protesters who organize a march, and they're all carrying the 1928 flag. So it's not art, it's not journalism, it's not academic inquiry, it's a protest. And they take the flags and they set them alight. And they say, we denounce apartheid. Now, it's not protected by the proviso. It's also quite obvious to anyone that this particular display is not an endorsement of apartheid. It's not to promote hatred. It's to denounce hatred. But nonetheless would be hit by the order. It would be viewed as a gratuitous display and would amount to hate speech. Now, the appellant doesn't need to list every single possible counterexample. There are 4 which I'll go through, and there are a few others. The point is that if any particular example can arise, where everyone would agree that's going to be declared hate speech, even though it is not hate speech because it doesn't meet the threshold requirements. There is a problem with the order. In other words, the judgment of the Court of Quo in its second order, which bans all public displays that don't meet into the proviso, is over-banning. And that's the problem. That's why there's a problem with making a declaration in advance. Another example is that you could have people using the flag to make a point. They trade on the dominant meaning of the flag. In other words, they say, we think that this flag does symbolize apartheid, and we think apartheid is abhorrent, and we think that you are acting in such a manner. There's a real case from Harvard. So students in a Harvard dormitory hung the Southern flag on their balconies, the Confederate flag. And that flag is viewed by many as deeply offensive and is seen as an endorsement for slavery. And so in protest, other students hung the swastika outside their doors. Not because they endorsed Nazism, but because they wanted to say what you're doing is as bad as endorsing Nazism. They were trading on the ordinary meaning of the swastika to condemn hatred. Now, that use of the symbol wouldn't be protected by the order. It would be viewed as a gratuitous display because it doesn't meet any of the proviso requirements. Similarly, in South Africa, if protesters want to say the new South African government is just as bad as the old South African government, and they wave the flag to point that out. And we have the example of the book, The New Apartheid, which the cover of that book weaves in the old South African flag and the new South African flag to make that point, to say the new regime is as bad as the old regime. Now that kind of political speech, many people are going to find as deeply offensive, as hurtful. They're going to say, how dare you compare the new South Africa with its wonderful constitution to the regressive, sinister apartheid state. But it's, there's a connection. In other words, the concern is that one of the reasons why these truly abstract findings ought not to be made, why courts ought not to decide that in advance, why they shouldn't have be granting opinions about things in the abstract, is because of these concrete cases, because there may be real cases that emerge. So there's a connection between the two. But it is a different kind of point to point out that these examples of flag waving would not violate the Act. But what the order does is it changes the rules. The order says anything that doesn't meet the proviso requirements is hate speech. And the court says, well, what we could then do is that if you wave the flag, you can come to court and you can only use the defences in the proviso. So,
can we take one step back and stop, and this is the last proposition I'll put to you on this point, and it's simply this. Given the broad standing requirements under Section 58 of the Constitution, the Human Rights Commission, for example, or the Nelson Mandela Foundation, for example, in this case, have brought an application to court without any facts relating to specific wrongdoers. In other words, that A, B, or C were the persons who were displaying the flag. Because it seems to me that they would be entitled to do so. Because they would be acting firstly in the public interest. And secondly, Kolani makes it clear in paragraph 110 that we must act proactively and preemptively in relation to discrimination. And that, I'm sure you can cover with one of the foundational values of the Constitution.
thus I submit two things. The first is that the Equality Court is a creature of statute. It only has the powers granted to it by the Act. It cannot do things that it is not empowered to do. And the Act is very clear. It says, after an incident has taken place. It may be desirable to have different legislation which allows a court to prognosticate and issue opinions. Ordinarily, however, we think that this is not the domain of courts, that this is the domain of the legislature. That if the legislature wants to make certain pronouncements about certain words and certain symbols, it must do so through a democratic process. Well, Justice, I'd submit that, first of all, the court doesn't have the power to make any declaration without an incident. It's just not within its domain. One cannot go and approach the court and say, we would like you to make a pronouncement on this hypothetical case. Here's an abstract question. We're going ex parte. Please tell us what we should do. And the court, in that situation, might have wonderful guidance to make. It might be the kind of thing that would be good for reconciliation and would be good for harmony, but it doesn't have the power. And if we think that it's important to have the rule of law, that courts are empowered only insofar as they have those powers, it may be desirable to do other things, but it can't do that. But on the question about whether the court could say other things, it might, for example, in such a judgment, say, while I don't have the power to grant any relief sought by the parties, I'm sympathetic to the question that's been brought before me. And then it could issue a diatribe for moral guidance. This is part of what Judge Lamont does in the AfriForum 11 matter of 2011, is this idea of expressing moral disdain. Now that's different to the idea of making something unlawful. And the Human Rights Commission itself acknowledges this, and this goes to the question about Kwalani's view about saying we must be proactive, is that there are other ways to deal with repugnant speech, that we can curb things that we think are immoral without using the strong arm of the law, without ultimately resorting to criminal sanctions, or to civil sanctions, or to imprisoning people because we don't like what they do. And the Commission itself states the following. This is at page 32 of my Heads of Arguments, at paragraph 109. It's released a document called Discussion Document Freedom of Expression, which details how complaints about repugnant speech should be dealt with. It says, the strong condemnation and public shaming attendant on these forms of speech ensures that we do not resort to a knee-jerk response of demanding that free expression be curtailed, but rather we encourage a constructive debate around these issues and allow the values of our constitutional democracy to shine through. We can express our confidence in our growing constitutional democracy and trust that society's moral outrage will be correctly placed, as was evident in the public debates around all these complaints before the Human Rights Commission. The Human Rights Commission may set the tone of these debates by issuing press statements condemning them and placing them firmly within the context of inappropriate speech for a democratic society. That is a legitimate preemptive measure. In other words, there is nothing at all wrong with this idea of counter-speech, of saying the Human Rights Commission would well be within its powers to have said, we saw people displaying the old South African flag on Black Monday, and we condemn it, and we think it's immoral, and we don't think that that has a place in society, and you ought not to do that. And those people should be counseled to do otherwise. They should be persuaded through counter-speech. They should be brought to their attention that what they're doing is hurtful and emotionally distressing.
But on your argument, the Human Rights Commission cannot approach the Equality Court.
It can approach the Equality Court if it cites those parties and says, you have breached the Act, explain yourself. And then there can be a hearing.
No,
and
in a case like this, where there has been an endorsement, I won't put it as high as an endorsement by AfriForum, but that where an organized, where a gathering or a protest has equality for, cannot approach the equality for court?
Well, Justice, firstly, I'd like to make it clear what the facts are on Black Monday. Black Monday protests were spontaneous. What you had was a multiracial set of people who showed disdain for farm murders, and there were protests across the country. AfriForum played a role in those protests, but there is no chief organizer of the Black Monday protests. What you had is spontaneous in reaction to a particular farm being killed. Now, at some of those protests, you had people displaying the flag. AfriForum itself has made it clear that it does not use the flag, and it denounces people using it. In other words, through moral talk, dissuades people from using it. So, and the case that was actually brought by the Mandela Foundation was to say that AfriForum and the Mandela Foundation have a dispute about the bounds of free speech and hate speech. Their dispute was not AfriForum is waving this flag. They must be held accountable for what they did for their incident. That was not their case.
Originated from a conflict situation, and the conflict situation was the fact that the flag was displayed. Why can they not approach the court for such an order?
The correct way to approach the court, would be to cite the flag wavers, to say, you have waved the flag. We are of the view that that amounts to hate speech. What is your view? And for the example that I gave of people burning the New South African flag, there is an answer, and that answer would show that it's not hate speech, that it was not to destroy democracy or call for the reaffirmation of apartheid. It was to show distaste for the June 16th ceremony being moved. So if we don't know what those particular waivers would have said, we cannot determine it in advance. And the examples so in other words, there is a way that it's not that everyone is powerless to deal with the problem. There could be legal recourse, but the legal recourse is very straightforward. It's that when there is a particular incident, lay a complaint against the person who performs the incident, have a determination with all of the facts as to whether that amounts to hate speech. If it does, a declarator can be made about that incident. And that may serve very well as guidance for other people. They might say, well, in that incident, that amounted to hate speech. Like in the John Kalani case, that article amounted to hate speech. Masuku's speech amounted to hate speech. That gives very good guidance to others, but it's based on concrete facts. It's very, very different from holding up in the air. We might think something similarly about the use of particularly obnoxious racial slurs. South Africa does not take the view that one cannot use a particular racial slur, ever. The idea is that you look at the context. My own friends for the Mandela Foundation use, I think, what everyone in this room would regard as the worst racial slur. And they use the word in its full term. They're quoting from the Constitutional Court in the SARS case. Now, mentioning that word is not to use it against someone, it's not to demean someone. Everybody understands there's a context in which that word can be used. And to ban the word in all cases would be going too far. And the same must follow for the symbols. In other words, we can't ban things in the abstract. We have to know the particular circumstances. There's an enormous difference between using a word to undermine someone's dignity and denigrate them versus using the word for illustrative purposes like the Constitutional Court does. And as I've given examples with the waving of the South African flag, there may well be a huge variety of cases that aren't going to meet the threshold test. And that's the difficulty with Part 2 of the Court's order, is it determines in advance that all of those wavings are hate speech unless you meet the proviso requirements. But there are examples, which the Human Rights Commission admits, don't meet the proviso requirements but aren't hate speech. And their submission is that the test should be altered. In other words, this court should say something like, all gratuitous displays that don't meet the test. In other words, gratuitous in the quota quo is meant to be synonymous with the proviso. In other words, those displays that are non-gratuitous meet the proviso requirements, and all other displays are gratuitous. The Human Rights Commission takes a different view, which is to say, well, maybe we should enlarge that category of non-gratuitous displays to remove all the worries that AfriForum has. Now, one way to do that would be to say, all cases of flag waving that actually meet the threshold test, all cases that are the actual propagation of hatred, that are inciting harm, and are themselves hurtful, in other words, meet the threshold requirements of the Act, those are hate speech. But the difficulty with that approach is that it's tautology. It's to say that any words which breach the Act, breach the Act. And we don't do that generally in law. We don't say that if you breach the Act, you've done something unlawful. It's obvious. The Act tells you this is what counts as unlawful. So there is no guidance in it. It's to say, if you ever utter any words that amount to hate speech, they are hate speech. That would be a tautology. So there's a difficulty in that approach. But if there is a concern that people don't like the waving of the old South African flag, as AfriForum does not like the waving of the old South African flag, there are ways to deal with it. And the way to deal with it is to bring a case on those particular facts, hear from both sides, and determine whether that speech, that particular incident amounts to hate speech. It may not. And similarly, that applies to the cases of harassment and unfair discrimination. The unfair discrimination law makes it very clear that you're meant to have a two-part inquiry, that you must hear all these reasons why it might not amount to unfair discrimination. In harassment, the particular context is going to make a big difference. One can imagine, for example, that every day you send someone a box of chocolates and flowers. If they're your intimate partner, it's not harassment. It's very, very sweet. If there's someone who has no interest in contact from you, and you do that to them every single day, that undoubtedly amounts to harassment. We have the same activity, but the context shifts. We cannot proclaim in advance that a particular activity amounts to harassment, or that it's unfair discrimination, or that it's hate speech.
So, Oppenheimer, in terms of Section 21, it seems to me that there is no specific requirement that there must always be another party. It seems as if it's been an inquiry in a prescribed manner to determine whether, as the case may be, the event has taken place. Now, in this case, it's come in course of the event took place. On what basis would we always then have to have another party?
Well, I'd submit that the nature of those proceedings, an inquiry doesn't mean that it's contrary to the whole adversarial process. In other words, the way those proceedings happen, in fact, is that the judge can play a more inquisitive role, that the judge can call for additional evidence. The judge can say, I'm not satisfied that I know everything that's gone on in this case. I've only heard from this witness. I think more should be done. So, for example, in the Kamalo case, Judge Sutherland was not satisfied that there was sufficient representation for Mr. Kamalo and called for an amicus to be brought in. Those are the kinds of inquisitorial powers that are different from an ordinary.
There was a protest, and at the protest there was backlash, and the demands of the protest were quite clear. Or certainly what the protest concerned was quite clear. To the public, that was the purpose of to protect farmers and so on. That was quite clear. There was no dispute about what it was about.
Yes, so in other words, but what is not in dispute is quite narrow. In other words, it is true that there were protests in which people showed disdain for farm murders. It's true that some people at those protests used the old South African flag. That's not in dispute. But the idea, and that there's no ex parte case, there's no one who's ever said, these people did something. I'm not going to cite them, I'm going to approach the Equality Court, and I want to declare about what they did. Do we think that's...
It seems to me what you're proposing is one takes a very lenient approach to symbols which are considered by the majority of South Africans to be very hostile. And that in every case one would have to be able to cite the other party.
The Human Rights Commission has done an outstanding job of tracking down particular alleged perpetrators of hate speech. In other words, Adam Katsovelos, for example, was in Greece. They tracked him down. There are photos of these protesters. In other words, we ordinarily think that, in a criminal setting, one doesn't say, well, this incident took place, we'd like a declaration from the court. You'd want to hear from the alleged criminal. You want to hear what they did. And we think that that is baked into our law, that if you're going to make a finding about what someone did, you should hear from them. That it must be the...
Constitution which is seeking to deal with the issues of the past, trying to move us into a future in which we share common values and we understand the past from which we moved and the horror of it. And it seems to me we don't take a stance to symbols that are very offensive to certain parts, and I would say the majority of South Africans, that we are inviting a kind of defiance of that common order that we're trying to bring.
Just as I submit that if part of the process of the Equality Court was this idea that it is a space for healing the divisions of the past, that it is a space for reconciliation, that you cannot have reconciliation in the absence of the party who you say has committed the horrible act. You can't reconcile in their absence. If the idea is to say, and what has happened in some of these cases is that the perpetrator comes into the equality court proceedings, and they are told that what you have done amounts to hate speech. And it dawns on them that what they have done is repugnant. There's an example that was dealt with outside of the Equality Court, but is an important example, of Nsebo Dlamini, who was the SRC leader at WITS. And he had said that he has an affinity with Hitler. And this was seen as deeply disturbing to the Jewish community, and the Jewish community asked him to apologize. And he underwent a process of going to the Holocaust Center, reflected on what he'd done, and apologized. And he said, I realized what I did was incredibly insensitive, and I now know why what I did was wrong, and I now go and actively counsel people not to display an affinity with Hitler. That reconciliation process could not be done in his absence. The fact that he was brought in... It's not softly to say, in other words, the approach that's being counseled is to say, if there is someone who's displaying the flag, and the view is that that undermines harmony and integration and all the constitutional values that we care about, cite them. Complain about what they did to them. Hear why they did it. Hear their explanation. It might be that their explanation turns out that everyone says, now that I understand what you're doing, it doesn't amount to hate speech. Or they might say, I realized that what I did was inappropriate and I'm sorry and I apologize. But we can't get the truth without them being present. And we think that this is important in law. I mean, ex parte cases are done incredibly rarely. This is fundamental because we care about reconciliation, because we care about, undoing the deep wounds in our society. You must have the other party present and let them explain. Imagine the case where Harvard says, these students had swastikas outside their dorm rooms. The only way that we can read this is that they are anti-Semites who long for another Holocaust. And we want a declarata. And they go to court, and the court says, well, given the information that I have, of course these people are anti-Semites. Of course this is hate speech. And the students say, the reason why we did it was to denounce the flags of people living in our dorm rooms who have the Confederate flag up. We show no affinity for Nazism. We are using it to denounce them. Suddenly your view would change. So because I heard the other side. And that's why it's so important to hear the other side. By the way, on this notion of banning flags, South Africa bans no symbols. One is free to wave the swastika in South Africa. Now, one view that's prevalent in the Jewish community is the idea that it's important to live in a society where people are free to do something so repugnant as that. So that you know the temperature, that you know how much of an appetite there is for anti-Semitism. If people are not free to do that, you lose that information. If anti-Semites are willing to tell you for free, this is who we are, this is what we believe, then you can keep tabs on them and you can up the counter speech. You can say this kind of speech, this kind of endorsement of Nazism is so dangerous. We need to talk about it more. We need to educate people more. We need to spend more time taking people to the Holocaust and Genocide Center. If they cannot say it, we don't know how big the problem is. What we find in South Africa is that even though the swastika is not banned, it is very, very rarely displayed. And when it is displayed, the Jewish community is able to react swiftly and counsel those people and often turn them into allies, as in the case of Nsebo Dlamini, who realized the gravity of what he'd done and can now be used to persuade other people that endorsing Nazism was a bad idea. And the same can, of course, be done with the old South African flag. Before this case, it was an incredibly rare thing to see the flag displayed. In other words, it struck people as surprising. But during the case, the flag became incredibly prevalent because it was displayed in news media all the time. And not necessarily in terms of the proviso. The proviso talks about fair and accurate reporting. That's different from this idea of journalistic expression. Maybe that many of those journalists peppered their stories with images of the flag without reporting on a particular incident. And you can imagine that the pain that people feel of seeing that flag suddenly became very prevalent. After the court's judgment, you had a number of people online changing their online avatars to the flag, not because they supported apartheid, but because they didn't like censorship. This is one of the difficulties of taking this approach, is that on the one hand, you muddle the meaning of the symbol. In other words, a symbol that most people would have recoiled from, and South Africans generally recoiled from it because they weren't waving it, suddenly becomes a protest symbol for some other cause. to say we don't like censorship, and so now you use the flag in that domain. And now it becomes unclear what the motive is. Also, those people that generally do hunger for apartheid now say, well, I don't want to be putting the flag up, so we now can't find out who they are. So you lose that information. So you have this strange backfire effect and also driving the hateful views underground. And my learned friends for the Mandela Foundation say, what's wrong with driving hateful views underground? We don't have to be exposed to them. The problem is, they don't just bubble up in words. When you drive those views underground, they fester. The best disinfectant is sunlight. And the problem with them festering is that they may then upsurge in more dangerous ways, that people may act out in violence, not just in displays of speech. And so that's one of the reasons why you build a society that allows people to say things that are distasteful, that are hurtful. And this court on many occasions has pronounced on it, the idea that free speech is not about protecting banal speech. No one requires the freedom to say, you know, the sun is shining and I love unicorns. You protect speech that is controversial, that is offensive. This court in Moyo says even speech that can instill fear in people, you protect it. Not because you like it, not because you endorse it, but because we realize that there are benefits to be had in allowing people to express their views in a way that falls short of actual violence. That if you allow a few small number of people to wave their flag, you can know who they are, you can get a sense of the temperature in society, and you can counter-dialogue it. And there are a plethora of ways that can be used to remove the hatred, to have reconciliation without resorting to censorship. And the difficulty is that we come from a society during apartheid where censorship was used with a very heavy hand. The National Party government took the view, if we can just stop this speech, if we can just stop these ideas from being spread, everything will be okay. And we're doing it because we want control and we think that's good for people. And of course it backfired spectacularly.
Do you accept that hate speech is not allowed?
Yes.
You do. And according to you, the display of the flag does not amount to hate speech?
One has to look at a particular incident. There might very well be.
Okay, there might very well be. What are those ones that would amount to hate speech?
Well, you could imagine an instance. We have a group of protesters waving the flag, accompanied by other kinds of actions, where they call for the extermination of people on the grounds of their race. So they sing something like Dibulu Bunu, but they reverse it. So they say, we call on our brothers to kill black people.
I'm not talking about flag, not other forms of hate speech. I'm just talking about the displaying of the flag.
The mere display.
The display of the flag. Do you accept that you say that in some instances it may amount to hate speech? What are those instances?
Well, I'd submit what the appellant has to show is that there are instances that clearly don't amount to hate speech.
No. The question is, what are the instances where the flag being used amount to hate speech?
Those instances are when the threshold test is met. In other words, when it first amounts to the propagation of hatred. In other words, the particular facts of that case must show that that's what's going on, that it is promoting hatred, that it is trying to instill hatred in those that are present at the event.
What does the old flag symbolize?
Well, I submit that the old flag can symbolize apartheid, but that in itself, if it has that dominant meaning, and it can symbolize all the underlying horrible things about apartheid as well, the idea that we didn't have the proper rule of law, that we had a sinister racialist system that excluded people on the grounds of their race. It can symbolize all of that. But, as I say, a particular instance of a display, you might be trading on that meaning to say something else, not to endorse. So just because the flag has a particular dominant meaning doesn't mean a display of that endorses it. As I say with the examples of...
So you are accepting that the flag can symbolize in apartheid, the system of apartheid.
Yes.
Which system was dealing to the majority of the people of the country?
Yes.
So if that is the case, would that not amount to hate speech?
No. In other words, the mere display doesn't. In other words, Justice, if you're with me, that in the swastika example that I gave, that those students who are displaying the swastika itself has a dominant meaning of the extermination of 6 million Jews and of countless Roma people. It is one of the most hateful global symbols. When they displayed that symbol, there was no endorsement of any of that. it was to denounce the display of the Confederate flag. And the point of that is to say that the flag can bear a certain meaning, but the context tells you whether it amounts to hate speech. Because we need to know, is it an endorsement of those principles?
But people will come and add to their own context. We are interested in this context. So people can come and say it was artistic, academic, journalistic. It is covered by the proviso. That is a different issue. We're talking about this context here. People are waving the flag in the protest march.
Yes, and we have no idea why. We are none the wiser. We have no idea why they did it, because they were not brought before the court. Well, here's the difficulty. They couldn't come and argue, because they weren't brought before the court. We have no idea why they did it. In other words, there is no countervailing set of facts. We are left in the scenario.
Sorry, keep going back to the question of a concrete case. I thought we had planned that file already, and that we are dealing with the requirements of Section 10 as stated in Quran. So I just need to establish with you what your submissions are precisely on that score. You have indicated in your submissions that the dominant, in your words, message conveyed by the flag is that is actually the old system, and the fact that one place was regarded as superior to another, and that it was a violation of the unity of most people, the majority of people in this country. Did I understand that correctly?
I would go even further to say that the system of apartheid invaded everyone's dignity to different degrees. It's an incredibly sinister system. And yes, in other words, the dominant meaning of the flag is that it represents that system.
Yes, it represents a system of bigotry and subjugation of one race group that was subjugated to another. Accept that.
Yes.
So it is therefore a message. It's a communication. It's a publication. Not so. I take it you accepted that this argument of words falls away.
Yes.
Definitely expression. The display is a form of expression.
Yes.
Accept that. So let's go to the second requirement. It's based in on one or more of the prohibited grounds.
It's going to depend on the context.
No. I mean, I thought we had agreed that there was the subjugation and the violation of the rights to dignity of the majority of people in this country. I thought we had agreed upon that.
Well, Justice, just to draw the distinction properly.
If that is so, then it is a prohibited ground. Is it not? Or am I missing something?
I'll draw the distinction neatly. In other words, it's very clear the system of apartheid discriminated on listed grounds. Without a doubt, it was racially infused. That's not in debate. The question is whether all displays are going to discriminate on that ground. And that's where I say the context would need to be present.
No, but if the flag as a symbol is representative or its dominant meaning is as we have debated, it doesn't matter. Because there would be a publication, there would be a communication of ideas based on one or more prohibited grounds. I mean, am I missing something?
Justice, in the example I give with the swastika, clearly Nazism is infused with anti-Semitism.
I don't want to unnecessarily curtail your argument. We're talking about this flag, and we have agreed on certain propositions. And all I want to establish of you is whether or not you accept that the dominant meaning, as you have indicated, constitutes a publication or communication based on one or more of the prohibited grounds under the Act.
Well, so for example, I'll give a South African flag case, is the community who's engaged in the service delivery protest, who are waving the South African flag. It's not a communication about race. It's a communication about the present government failing to deliver services. Right? So in other words, in that particular context, it doesn't meet the first part of the test. In other words, it is communication, but it's not on listed ground given those facts. In other words, all the protesters are black. You imagine the community that governs them is black. It's not a racial communication.
You're talking about the new South African.
No, the old. In other words, one of the examples that I give in my heads of argument, and there is a factual case that's similar, is that you have a service delivery protest where the protesters use the old South African flag. The reason why they use the old South African flag is to say that you are as bad as the apartheid government. And in that regard, what they mean is in terms of the provision of services. In other words, during apartheid we were marginalized, we were treated badly, we didn't have access to basic resources, and you are just as bad. That communication...
Analogy was Oppenheimer, because if the flag is symbolizing, if the flag itself, the dominant symbolism of the flag is bigotry and oppression, how can it ever have any other meaning than it's displayed?
Well, in other words, you are trading on the meaning. You are saying, those protesters say, this flag is this is a symbol of oppression. You are acting in an oppressive manner. That's why I'm saying you're acting like this. But that communication, as I say, is about saying you are acting in an oppressive manner. The community wouldn't be making the claim that we're being oppressed on the grounds of race. So it's not a communication about race, it's a communication about oppression. So given the facts of that particular example, it's not a racial communication. Now obviously the flag can convey racial messages, without a doubt. But you need to look at in particular circumstances to say, well, did it in this case? The point is that, in other words, a symbol can have a dominant meaning. But one way to work out what is meant by the incident or by the speakers is to look at all the rest of the facts. And you can say, in this instance, this particular display is not about race. It's about another form of oppression. And that would, in other words, wouldn't meet the next test. It wouldn't meet any of the other tests as well. It wouldn't be propagating hatred. It wouldn't be that the speech itself is harmful. It wouldn't be inciting harm against anyone in that particular set of facts. By the way, that set of facts does not meet the proviso. It's not journalism. It's not art. It's not academic inquiry. It's a protest. It's a protest that trades on the dominant meaning of the flag to denounce a particular municipality or particular government. It would not be protected speech. It would be declared as hate speech in terms of the current order, and I submit wrongly so, because it doesn't meet the requirements. Now, the real-life example is in 2017. There were a series of protests in Pretoria, and two black protesters hung the old South African flag on a tree. And they said things were better under this regime, and they said there wasn't the widespread crime and use of drugs. Onlookers looked at the flag and said, this is like Israelites who yearn to return back to Egypt. In other words, you had a conversation, people saying this is what you are doing is strange. But those protesters were not doing it for a racist motive. You might think they're wrong and they should be counseled, and they were counselled by onlookers who said, you're Israelites trying to return to Egypt.
Remember, the test is not a subjective test. You don't look at the mind of the person who's doing it. At the intention, it's an objective test.
Yes, it is an objective test.
And that's confirmed in the
It is an objective test, but the objective test requires particular facts. In other words, it's not about peering into the mind. It's about saying, looking at the full set of facts, we must determine what the intention is. And given a full set of facts, we might make different determinations. It's why the context matters so much.
But Mr. Oppenheimer, the problem with the argument that exists, I think it was the case in which Justice Cameron said that you cannot find any form of justification where it is based on racism. If the flag represents racism, you cannot have any form of justification for its, not necessarily for its, he wasn't talking about the flag, but where you have racism as significantly dominant, it seems to me that it is the only representation. It's the only message that's conveyed by this flag because of the approach that our courts have taken, particularly having regard to the international instruments such as the International Convention on Civil and Political Rights and the ICERD. I forget the full name of it. So based on that, you can never represent something which is noble.
Well, Justice, first of all, I want to make a few claims. The claim is not that the flag represents something noble. One can have a situation where the particular display, what is meant to be conveyed by the flag, is that this is a symbol of racism. And then it can be used in the context to denounce another party, to accuse them of racism, to say, you're acting like this. It's not to endorse, and that's the difference. In other words, the Foundation's claim is that all displays amount to an endorsement. Now, the examples that I've given which fall outside of the proviso don't amount to an endorsement. The second is that racism is repugnant, and racism must be combated. But we must read the law as it stands. If the Equality Act said that any act of racism amounts to hate speech, it would say that in the Act. It doesn't say that. Kwalani decides that it's not a disjunctive test. In other words, the mere promotion of hatred on the grounds of race is not hate speech. It must be accompanied by one of the other two legs. It must amount to harm, which is of a high threshold, or the incitement to harm. In other words, mere racism on its own, while repugnant, is not hit by the Act. We might think that the Act should be different, but the Constitution sets a threshold as well. And this is why the Constitutional Court has proclaimed this is what the Act can do. The Constitution says that you cannot have the advocacy of hatred on 4 grounds, and that constitutes the incitement to harm. The Constitution is clear. It says that's not protected speech. What we have from the Court is to say, well, we can intrude a bit further. We can say that if the speech itself is harmful, then it also amounts to hate speech. Don't have to have the incitement leg. But mere racism on its own is not prohibited. We might think it's distasteful. We might think that as a society we have a duty to combat it. But that's different from saying that that's what the law says. We must be bound by what the law says, and the Constitutional Court has proclaimed. Yes. Is it 25 past? What time is it now? Yeah. Here's my suspicion, because I think we aren't going to give any questions. This is very quick.
The masters make it tricky. I have the benefit of seeing your name on there. I got written this myself. Her name was oh. I've never met her. I don't know. I was just pulled in at the last minute. No. She's at the bridge. I think so. I mean, I don't know. I just know that she fell out. So I heard you guys were yanked in here for the essay to receive because of the whole challenge in Section 10. And Jessica. Yeah. Right. Yeah. No, but it's very cool. Did you get to
Same tax, so 20
still at, were you at ENS?
So, I'm sorry?
Oh, it's right under Tembeka. Let's check. No, I think it's afterwards. No, that's actually because I thought you guys were colleagues together. Well, you were born with Didi. Yes, that's why you were. No, so we were together. And then a separate work tracks, and he was like, and then she went to the company after the Yeah, yeah. No, many. I only came in 2018.
Well, also it's pre-COVID, so it feels.
Yeah, so that's like what, 2-3 years ago. Oh, it's been great. So I took a sabbatical last year to go club in the Concord. So I did that, and now I'm back. Jafdan Rogers, because he was retiring. So my last couple of months I got Rogers, and he was brilliant.
No, that's I'm sorry. Most of the things
It's fast, but I mean, so was Jafdan. Jafdan's so great. I know.
So we still need to cover some.
but I feel like I'm doing it like I'm like a snake.
Yeah, and you've been going round and round, and yeah, he is. And he'll make a point. He'll ask us something like, "Is that a trick question?" Obviously, it's not. And everyone else doesn't see the point. And then once he makes it, we're just like, "How did we miss it?"
I will just leave now. I'm sorry, I wasn't.
Not even your plug. Yeah, no, he was really, really good. But yeah, it's really great to be back. It's really great to. Also, I never left, which is.
It's nice to feel like that. It's nice to feel like the animation.
I mean, I don't know if you call it a mental breakfast. It feels like a busy. It's a different kind of busy for sure. I think this kind of busy is kind of.
in places that you say are private places. What then? Meaning that the issue is not about the private place or the location, but it's about the public display, the effect that it has to the target group.
Well, I submit that there are two reasons given in Kulani. In paragraph 117, just above, the court says, on most private communications, and being able to freely communicate in one's private and personal sphere form part and parcel of the inner sanctum of the person and are in the truly personal realm. And the court says then hate speech provisions, even those that attach civil liability, should not extend to private communications because that would be incongruent with the very purpose of regulating hate speech. Now, so that's the second part. In other words, there's a purpose which is that the speech itself could cause the harm to the targeted group. But there's another reason, which is that you've got a right to privacy. There's an inner sanctum. Now, what the court to quo does is say that any private display in a home, for example, is going to count as hate speech. It's declared as such. Fails to take into account the important role of privacy. I cite the example of Case, where the Constitutional Court was dealing with pornography. And there the court says, what erotic material I may choose to keep within the privacy of my home, and only for my personal use there, is nobody's business but mine. It is certainly not the business of society or the state. Any ban imposed on my possession of such material for that solitary purpose invades the personal privacy which the Constitution provides. Well, what the Equality Court does is to say, we can imagine a situation in which your private display becomes public in the sense that someone comes into your house and is exposed to it. Yes, well, I suppose the question then becomes whether it is a private display or a public display. But the idea is that in Kulani it's made clear that the private displays are protected, firstly because of the right to privacy, and secondly because there is a lack of a likelihood of exposure. But both play a role. In other words, the right to privacy plays a role. It might be the case, for example, that, let's say, someone did have a private display in their house, and a guest came in and said, I'm going to lay a complaint against you for this. I see that you have this private display. I've now been exposed. I would think that that person could say, well, it's a private display, and I have an inner sanctum, and I have a right to privacy, and I have a right to keep it up in my house. In the same way that someone who stumbled upon someone's collection of erotica said, it's the same. It's my private property. You may be offended by this material, but it is, as Case says, none of your business but mine. The idea that if we in advance determine that all private displays amount to hate speech, that you could imagine a situation where someone says, I've heard that so-and-so has a flag at their house, in their cupboard. And you could have an investigation. Police could arrive at someone's house and say, we've been told that you have such a display at your house. The judgment, so if I can read out the section from the set, paragraph 58, Quality Court held, the question of display of the old flag in private spaces was briefly argued. Despite years of apartheid rule, the lives of various races in South Africa have never been compartmentalized. That was the impracticality that apartheid rule sought to and never achieved. There is therefore hardly any space which is private to the one race to the exclusion of the other, especially in modern-day South Africa. Thus, displaying the flag in private spaces like homes and schools is equally unacceptable, offensive and hurtful, as black people are invariably employed and exposed in other ways to such spaces. The display in such spaces thus also constitutes hate speech under the Equality Act. And then it goes on to sort of say that such displays make young people believe that it is acceptable to harbour racist views and then to manifest them publicly. So it does seem to target private displays in private homes and in private schools. And the argument is that Kulani says that that cannot be done, that it goes too far. And on that basis, the court erred. That if the right to privacy is meant to be taken seriously, I mean, of course, with all the other arguments that I've made, is that one has to look at the particular display and determine whether it amounts to hate speech. By the way, for example, historical displays, that's not mentioned in the proviso. What's mentioned in the proviso is fair and accurate reporting, academic and artistic. And then, of course, what's not mentioned is how the proviso goes on to say any other information or notice in terms of Section 16 of the Constitution. The question is unclear, I think, to some extent, as to what that means. Does it refer back to the Constitution and say that, in other words, any right, any right in the full free speech right is protected? But the point is that you can imagine an historical display that someone has. In other words, they say, let's have a look at the flags of South Africa since 1652. And it's a historical display. It's not clear that those meet the proviso, but it's also not clear that it amounts to hate speech. It's not clear that the purpose of that display is to promote hatred or incite harm against anyone, or that it would be harmful. It falls outside the proviso. It's a private display, but would breach the court's order. Similarly, one of the examples that I give is you have, for example, military reenactments or military displays. So there's the Moth Museum, which has military regalia from South Africa's various wars. And if you have the original uniforms, you're going to have the old South African flag on those uniforms. And during World War II, when South African troops were fighting Adolf Hitler, they were wearing those uniforms with that flag. And their uniform is displayed. It's not to venerate apartheid. It's to venerate the soldiers that fought Nazis. Again, my point is that the context matters. That we cannot determine in the abstract whether a particular display amounts to hate speech. We need some facts. There may very well be instances that amount to it. And in those instances, someone must bring a case. And must bring a case against a particular person. And the court must determine, does that meet the hate speech requirements? And every time to do that, the full test must be met. What the current judgment does, it says we don't need to look at Section 10.1. It's assumed it's hate speech. The only defences that one could ever raise are the ones in the proviso. And the difficulty with that, of course, is that examples I've given fall outside the proviso, but don't meet the requirements in 10. And so the person has then done something which didn't amount to hate speech, engaged in a display that didn't amount to hate speech, fall outside the proviso, and now they have breached the Equality Act. That seems like a problem. The other problem is that it might be the case that every single person in this room, and every single person watching on television, dislikes the old South African flag. Says, you know what? Would we really be worse off if all copies of it were destroyed and it was burnt in the fire and no one ever waved it ever again? The problem is that a principle gets created. And the principle will apply to other cases. And the question is, what else will be hit by that principle? There were two things that happened quite soon after the Court handed down judgment. First was that within hours, the EFF put out a statement saying that the next flag that should be banned
Justice, can you hear us? Please unmute your mic.
As I was saying, mere hours after the Court of Quo delivered its judgment, the EFF released a statement saying that the next flag that ought to be banned is the national flag of Israel, on the grounds that Israel is an apartheid state. So the concern that was raised by the appellant in the original proceedings was that it will not end with a ban on the old South African flag, that the principle that will be created can be used by others for their particular political purpose to ban a series of other symbols. The next symbol that was targeted in litigation is the Springbok symbol. Now, a very similar kind of example that Mr. Hatang gives could be raised about that symbol. One can imagine the sense of exclusion one sees whenever one watches the Springboks with that symbol. Now, the Springboks was a racially segregated team during apartheid. Black players were not entitled to play. The Springboks were not able to play internationally. That symbol of the Springbok was intimately connected with apartheid. And many people that view that symbol could very well be reminded of all the other indignities that they endured during apartheid. They could imagine exactly the kinds of things that Mr. Hatang has given as examples of being racially abused, of being belittled, thinking about his grandmother when they see that symbol. And the case has been brought on the basis that the old South African flag from 1928 is an apartheid symbol, well, so is the Springbok symbol. And it's a symbol that is seen readily. In other words, whenever one watches the South African national team competing in a rugby match, you have to endure seeing that symbol. And you can imagine someone saying, this brings back all the hurt that I felt during apartheid, all that exclusion, that I myself would have been a promising rugby player, and I was not able to compete on this team because of this racist system that was in place. And if the precedent that is set is that this flag amounts to hate speech, well, then a very similar analogous case can be brought with regards to the Springbok symbol. The EFF have also called for the stem to be banned. The stem, portions of it currently form part of our national anthem. The argument might be made that, and this was testimony from Mr. Malema in a recent trial, that people were tortured while hearing the stem sung. You can imagine the trauma they hear when they sing their national anthem, and also an anthem that is sung on many public occasions. And on that basis, that it brings back these painful memories, that song should go, should be removed.
I'm not quite sure what this example is held to the same time. The same, or the part of it, the national anthem, and the Springbok anthem were adopted by the nation after 1994. Now, this flag, which is in the border of the does not fall inside the table. It symbolizes apartheid, which was very violent in trying to be seen. So if we just restrict ourselves to that.
Well, first of all, it might be the case to say it's adopted by the nation doesn't mean that every single individual says, I gave assent to that. In other words, an individual could say, when I see that, I didn't consent. I never said that I'm okay with this symbol being present. There are many people who publicly denounce it. In other words, you have a major political party saying, we don't accept this. We as a nation don't accept the dissent. You have an individual who's brought litigation about the Springbok symbol. Now, on the question of crimes against humanity, I think it's important to have a context as to what the crimes against humanity are. So Article 7 of the Rome Statute sets out the crimes against humanity, and 1G describes the crime of apartheid as a crime against humanity. But there are a number of other things that are described as crimes against humanity. Murder, extermination, deportation, torture, enslavement, persecution on a listed ground. Now, some of the other examples of flags that we say would be hit are going to meet these criteria. So, for example, we know that the hammer and sickle is the flag that represents communism. And we know that in those communist regimes, people were murdered, they were persecuted in vast numbers. In Cambodia, a third of the population was exterminated. We know, for example, that there are 74 countries in the world that have strong prohibitions against homosexuality. They persecute people on the grounds of their sexual orientation. That in some of those countries you can be beheaded on the grounds that you are gay. We know that the Union Jack, the flag of the British Empire, has presided over much suffering, colonialism, death, torture. That in South Africa during the Boer War, 28,000 Afrikaner women and children were killed in camps. You can imagine that the idea that these are also symbols of crimes against humanity. Now, of course, the Equality Act doesn't use the term crimes against humanity. But my point is to say that if that is the standard bearer to be used, there are second-order effects. It will not just be the old South African flag that gets banned. That crimes against humanity have been perpetrated by other nations, that those flags can be viewed as symbols of those crimes, and that when people see those symbols, they might very well say, the old South African flag was banned, precedent was set, there is a good case to be made that those symbols should be banned as well. And not in particular cases, but in the abstract. And we don't even need another story. In other words, someone can approach the court ex parte and say, whenever I see the SACP flag, it reminds me of what I endured during the Soviet Union's rule, that I was a survivor of a gulag, and meets the threshold test and says, I want all displays banned, and I don't need to hear from the SACP about it either. They don't need to explain what importance it is for them. We can determine this in the abstract. We can have a banning order. The other thing that's worth noticing, my friend for the Human Rights Commission supplemented his papers and provided examples of other countries that regulate symbols. And the manner in which they regulate it is through legislation. It's very specific. So Germany, for example, says the following symbols amount to anti-constitutional symbols: the swastika, the hammer and sickle, the five-pointed star. These are all the cases, in quite a lot of detail, in which you're entitled to use it. These are the cases when you're not. These are the sanctions. Now, why does it matter that it comes about through that process? Because we think that the job of the legislature is to make the law. That the people ought to know in advance whether what they're doing is illegal or not, that there's a democratic process. You can vote for the politicians that you think are going to produce a particular law, that you've got a democratic process in that. The general view is that judges must be interpreting the law and applying the law. We don't have a statute that targets symbols in South Africa. We don't have a statute that says the old South African flag, the swastika, the hammer and sickle are illegal. These are the examples when you can use them. These are the examples that you can't. What we have in the Equality Court judgment is legislation from the bench. We have a situation where, say, I don't like this. This flag is deeply offensive and hurtful, and I'm going to ban it in all cases, barring those in the proviso. And there's something deeply undemocratic about that. If it is the case, on that second point, no. In other words, just what's not disputed is that the flag bears a dominant meaning. Just that there's a second, the last point is that it constitutes unfair discrimination. That's a legal question. No, it isn't disputed. It's heavily disputed in the papers. The argument is that to determine whether something... Well, an argument that was suggested that the way that the Act is set out, that there's a prohibition on unfair discrimination in terms of Section 7 of the Act, and it envisions a particular process, which is that there's a burden of proof on the one side to show that it amounts, there's a determination of fairness and unfairness in Section 14, there's there's a number of contextual factors that are taken into account to determine whether something is fair or unfair. And the point is that this is the Act makes it incredibly clear that you cannot make determinations of unfairness in advance, that you require a set of facts before you. And of course, the case that AfriForum was required to meet was to deal with the question of whether all prospective displays of the flag amount to hate speech, unfair discrimination, and harassment. That was the case that AfriForum had to meet, which was on that abstract question. Now, the case that the Foundation could have made was to have said, this particular incident where these flag wavers committed this conduct, brought them to court, and said, explain yourselves in terms of the Act. We say this amounts to unfair discrimination, harassment, and hate speech. What is your side of the story? And they could have provided some evidence. In other words, there's a reason why it's uncontested, because AfriForum was never called to meet that case. What happens is a realization in the closing hours of the litigation to say, there is no incident here, so therefore the court has no power. So let's ask for a declaration about an incident, which we don't ask for in the beginning. We don't ask for an application. We don't cite the parties who would be involved in an incident. We cite AfriForum because we want to have a discussion about what the law ought to be, prospectively. So the argument is that on particular displays, it might very well be that there's a particular display that could meet the threshold of unfair discrimination. And the Act tells you how to find out. Hold an inquiry, you hear from both sides, then you can decide. But you cannot decide in advance that it's unfair discrimination. What you can say is that apartheid involved lots of unfair discrimination. That's fine. You can say that the flag represents unfair discrimination. But that's different to saying that every single display amounts to it. And that's the important distinction that I'm trying to make, is that it can have a dominant meaning, one can trade on that dominant meaning, without itself amounting to unfair discrimination or hate speech. In the example I've given, where one is saying, you are acting as bad as the apartheid government, or you are as bad as the Nazis. You are not endorsing it, you are using it to denounce someone else. Again, an example not covered by the proviso, clearly not hate speech. And that's why these things have to be dealt with on a case-by-case basis. All of the things that this court wants, which is the ability to make moral pronouncements on displays of the flag, can be done. They must just be done using the law. In other words, some organisation is free to bring a case against a particular flag waver and say the facts of this case are as follows. This is why it amounts to harassment, unfair discrimination, hate speech. The other side can participate and explain why it doesn't. They might lose. There can be a declaration about that particular display. And all of the moral opprobrium can be included in the judgment to say this is why it's immoral, why in the particular instance what you did was terrible, and why it amounts to the legal thresholds. That can all be done. But to determine in advance that all displays are always going to meet those thresholds goes beyond the powers of the court and would be improper, and opens up the floodgates for all these other examples, all these other cases of symbols, where if the thresholds are so low that, to instead of treading lightly, say, well, someone's very upset, you can approach a court ex parte, you don't need to cite anybody, you can get a declarator, and you can determine in advance the Israeli flag is hate speech, the 74 countries that have terribly homophobic laws, in displays of those flags are hate speech, they're homophobic. You could do all that in advance, and what will happen is we'll just restrict speech further and further and further and further. And there's a danger in that. I think everybody would recognize that there's a danger in banning things left, right, and center. That there's value in being able to have these ideas around, so you can combat them, so you can persuade those countries that have homophobic laws to not have them. I think, first of all, it must be recognized that the nature of the protest is throughout the country. In other words, what it is multiple spontaneous protests. The stance was that if anyone brings an South African flag to an AfriForum rally, he'll be asked to put it away, that AfriForum does not endorse the waving of the flag. That's the AfriForum stance. There's no evidence, for example, that any AfriForum member displayed the flag, that any AfriForum member was present when a flag was displayed. There's a paucity of evidence about the number of displays, the motivations for those displays, the context of those displays. Yes. But of course, that's only one bit of the puzzle. As I said, for example, if it's it's common cause that a group of people were burning the New South African flag, that wouldn't tell us whether the act amounted to hate speech or not. We need to know more. We need to know why. We need to know what the context was of the burning. And once that context is filled in, we can make a determination. And as I would say, in the real case I give of the New South African flag being burnt, people would not think that any of that was motivated by racial hatred. So, this is at the kind of core of AfriForum's case is, these things can be done. In other words, one can make determinations, let's just do it through a legal process. And you need to have particular facts. And you need to decide, and this is how all of these equality court cases are done. Declarations are made about particular instances. And I think one of the reasons, for example, why in the original Dibulu case there was an appeal and why there was a settlement is its recognition that there are going to be instances where singing Dibulu are going to be clear acts of hate speech when it meets the threshold test, and there are going to be some cases where it doesn't meet the threshold test. You have to decide on a case-by-case basis. That doesn't stop a court from creating some sort of general moral landscape and saying, well, the general rule is this, and this is why we think this. But that's very different from declaring something, from making legal presumptions in advance. What the declarator does, it says all of these instances necessarily amount to incitement to harm, harmfulness, propagation of hatred. Well, this goes to the heart of it. Why is AfriForum here? AfriForum doesn't like the old South African flag. It tells its members don't display it. It says if you bring one, put it away. Why are we here? Because free speech matters. Because this notion that you can disagree with someone virulently and think what they're doing is wrong, disagree with their ideas, but nonetheless fight for their right to say it is an important value. There's an enormous difference when private parties say to each other, look, if you want to be associated with me, there's certain conduct that's required of you. Versus the state being able to say that you will be sanctioned, that you can be fined, this is illegal. For example, one might say, when you come to my house for dinner, there's certain codes of conduct that I expect of you. That if you behave in a certain way, I'm going to ask you to leave. But a person can hold that view without thinking that any of that conduct should be illegal. There's a difference between what we think is immoral and what ought to be illegal. I think a lot of people are going to take the view that adultery is immoral, that you have done something deeply wrong to the person that you've committed the act of adultery with. But we don't think it ought to be illegal. There's a big difference between saying the state can fine you or arrest you because you did this immoral thing. We think, for example, that racial slurs are immoral, but we don't criminalize particular racial slurs. We look at particular instances and we say, well, in this instance, we think it met the threshold. We think that swearing might be wrong, that viewing pornography might be wrong. Very different from saying that the state must regulate it, that it must be illegal. We don't think that everything that is improper, impolite, immoral must be illegal. And so that's why it's perfectly consistent for AfriForum to say, if you want to be associated with us, this is what our code of conduct is. It's very different from saying that we think that the state ought to make it illegal. And that distinction is vital.
I know you can ask a number of questions for events, but you need to let us know if you do that all the time.
Yes. I can just confer with my attorney. Justice Meyer, I think I've covered all the grounds that are necessary to cover. Why free speech is important, why we ought to permit in law certain kinds of conduct that we disapprove of, that is repugnant, immoral, distasteful, and offensive, why there will be ramifications beyond the banning of the old South African flag for all sorts of other symbols and other flags that will open up the floodgates, and why that's dangerous, why there are remedies available from this court and from society to express its moral disdain, that is the best way of dealing with it. Why, importantly, the Equality Court lacked the power to have granted the orders that it did, for two reasons. One, there was no true respondent in the first order regarding the displays. Secondly, that a court can only make declaratory relief about particular instances, not prospectively, and that the case law shows the general approach is to condemn particular acts, not to make declaratives in the abstract. That through a number of examples that I provided, there will be displays that don't meet the threshold tests, but will nonetheless be declared as hate speech, and that shows the problem with the order. And I would submit that in the circumstances, the order of the court of quo ought to be set aside. On the question... Yes. So on the question of costs, we submit that BioWatch applies in relation to the state parties, so the Human Rights Commission and the Minister, that if AfriForum is not successful, that it ought not to be mulcting those costs. And from what I gather from their heads of argument, they don't see costs against AfriForum. The original agreement between the Mandela Foundation and AfriForum in the court of quo was that neither side would see costs against each other. Now either side does see costs against each other, dependent on success. I have no further submissions.
Thank you, Justice Meyer. If I may ask for permission to remove my mask. I propose to ask for the dismissal of the appeal with costs. I shall address three topics in my argument. The first is an analysis of the pleadings to show that there was a concrete issue with concrete facts before the Equality Court. The second is to explain the meaning of the old South African flag, both from a historical and a contemporary perspective. The third is to apply that meaning to these facts in the light of the Kwelane judgment. Now, on the third issue, I shall urge the court to find that displays in public spaces are as hurtful and harmful as displays in private spaces. In fact, the law cries out for regulation of displays in private spaces more than it does for displays in public spaces because of the asymmetry of power in private spaces, homes, farms, churches, private schools. Let me start then with the correct analysis of the pleadings. The court will find the pleadings from volume 1, the case brought by the Nelson Mandela Foundation starts at page 9. That's the affidavit of Mr. Hatang. In paragraph 7, he explains the dispute as follows. A dispute has arisen between the Foundation and AfriForum concerning contemporary displays of the previous official flag of South Africa, which was introduced on 31 May 1928, with the entry into force of the Union, Nationality and Flags Act 40 of 1927, which was abolished on 27 April 1994. He then explains what that dispute is at paragraph 8. It says, the Foundation holds the view that any gratuitous display of the old flag constitutes hate speech and harassment prohibited by PEPUDA. A display would be gratuitous if it does not serve any genuine journalistic, academic, or artistic purpose in the public interest. Then he summarizes the view of AfriForum, which has been repeated today, that they have articulated an alternative view that even gratuitous displays of the old flag constitute protected speech under Section 16 of the Constitution, and has indicated that it would oppose any application for an order declaring displays of the old flag to be prohibited. So right at the outset, it was clear that this would be an application for a declaratory order applying generically. And AfriForum at the commencement stated that it would oppose that. Now, the context of that dispute is set out from paragraph 11 of that page 11. The essence of the story is that on 30th October 2017, there were nationwide demonstrations under the title Black Monday. Now, these were organized under the auspices of AfriForum and other organizations. The allegation is made, and it is common cause, that AfriForum played a leading role in these demonstrations and announced as follows in a statement issued on the same day. It says, today's gatherings are only the beginning of a campaign that will ripple outward even further and will become a bigger campaign. AfriForum already at today's gathering announced campaigns and safety plans in the fight against farm attacks and murders. So this was their event. They invited people to this Black Monday. At paragraph 12, it was widely reported that the old flag was displayed at some of the Black Monday demonstrations. And there were various examples that put up that show that the display was organized at an event organized by AfriForum, ostensibly to protest against farm murders. And then at page 13, it is then explained at paragraph 17. While these attitudes may not have animated all of the leaders and demonstrators on Black Monday, the occasion clearly fostered an enabling environment for these attitudes to flourish and for those holding them to feel comfortable, not only in bringing but brandishing the old flag without any fear or ostracism by the other demonstrators. So the criticism is made directly against AfriForum and the organizers that they have lit the fire, they must take the consequences. The dispute with AfriForum is then repeated at paragraph 19 at page 14. And this is illustrated in a debate with Mr. Kriel and Mr. Hatang. And Mr. Hatang, well, Mr. Kriel, it is explained what Mr. Kriel said from page 15, A, B, C, D, and E. And then it is said at E, I indicated that the foundation was seriously considering a court application to have displays of the old flag declared unlawful. In response, Mr. Kriel laughed at me, accused me of trying to turn South Africa into a communist police state, and asserted that AfriForum would be willing to oppose any such court application. So AfriForum regarded this with a bit of derision and said it would oppose the application. And then at page 17, paragraph 24, well, paragraph 23 first at page 16, the foundation respectfully submits that any gratuitous displays of the old flag contravenes the Equality Act in 3 ways. 1, it is unfair discrimination. 2, it is hate speech. 3, it is harassment. And then paragraph 24, it's also made clear there at line 9. Gratuitous displays of the old flag are egregious examples of such behavior and should be met with these remedies. Then it says, but Black Monday and the resulting dispute that erupted between the Foundation and AfriForum have revealed the need for a declaratory order to this effect. Otherwise, many potential perpetrators and victims of this discrimination, hatred, and harassment will remain unaware of where the constitutional boundaries lie. So, 2 things ought to be said. The first one is that it was always clear that the dispute is about gratuitous displays. Secondly, it was always clear that the display at Black Monday was a gratuitous display. The position taken by AfriForum, it was interesting, Justice Savage, because you put this question, what was the attitude that you took in relation to the litigation? And you got an evasive answer, which was characteristic of the argument we listened to this morning. At page 98, AfriForum actually answers its attitude on Black Monday protests, and it defends them. It says at paragraph 62, the Black Monday protests were a spontaneous response to the murder of Western Cape farmer Hubert Conradi. Some of the reporting on the protests missed a pivotal issue of the brutal and frequent farm murders that have been carried out across the country, and instead focused their attention on claims that some protesters were carrying the old flag. The ENCA journalists, and they accuse now this journalist, Nicholas Bauer, of tweeting the following images of people wearing the old flag and burning the new flag, while creating the false impression that they were taking part in the Black Monday protests. Then he later issued an apology. But the bottom line is that this was our protest, and it was against farm murders, and that the reporting that says some people displayed the flag is wrong, but they admit that the flag indeed was displayed. But they explained their attitude a page earlier, page 97, under the heading, responding to offensive speech, where they say, paragraph 57, the best remedy for offensive speech is counter-dialogue. When people make racist statements or use offensive symbols, an opportunity is created for public discussion. Paragraph 58, most South Africans recoiled from the old flag and openly denounced apartheid as a crime against humanity. Now, if you stop there and you ask yourself the question, what is the attitude of AfriForum on the old flag? It is not talking about its own attitude, it is talking about other people who denounced the old flag because of its association with apartheid, which was a crime against humanity. AfriForum itself does not denounce the old flag. It does not regard it as amounting to a crime, apartheid amounting to a crime against humanity. Instead, its attitude is revealed in the following sentence. Whenever anyone waves an old flag, it is an opportunity to engage that person and persuade them of the error of their ways. So that's the Coffee and the Cook sisters conversation. Paragraph 59, Mr. Hatang relates a personal story about how he felt when he heard about the old flag being waved. Now you remember that in the founding affidavit, Mr. Hatang said it reminded him as a child when he was asked in a white place, "Wat soek julle, yo K-word?" And this is how they respond to that, and it's actually quite demeaning. He says, during apartheid, the old flag was held aloft as a symbol of the past regime's power. At the time, it was seen as a constant reminder of an oppressive and a racist system. Today, the flag has largely been relegated to the dustbin of history. It is very unusual to see it displayed anywhere. On the rare occasion that the flag is displayed, it has the potential to be viewed in a new light. It can be viewed as a relic of a system that has been dismantled. In the new South Africa, we have a constitution that aims to treat everyone equally before the law and which recognizes people's inherent dignity regardless of their race. Now they talk about Mr. Hatang. The next time Mr. Hatang hears about the old flag being waved, he could use the opportunity to reflect on how far we have come as a nation. That's their attitude. So they explicitly embrace the waving of the old flag. They say that the victims of apartheid, like Mr. Hatang, must regard this as an opportunity to be engaged. And they say other people think that this is a denouncement of the crime against, of the crime of apartheid. So it's clear then that the dispute was between the Nelson Mandela Foundation and AfriForum, and the parameters of the dispute are clearly set out in the pleadings. And the argument we heard today is simply a fiction of AfriForum's own imagination. We move then to the next topic. If it's clear that is what was pleaded, and the judge understood correctly what was pleaded, we look at the judgment itself. The judgment at page 404, volume 3, recognizes that the dispute is fully pleaded in relation to Black Monday itself and in relation to general displays of the flag. And that is why at paragraph 205, the first declaration is targeted at the old flag, at the old flag in relation to Black Monday. And you will see that 404, page 205, and 405. And then paragraph 2 is a generic order, the declaration that any display of that flag would then be hate speech. And my learned friend, I heard him talking about the Malema versus AfriForum case. That judgment is also clear. It finds that the singing of Dogulipun is hate speech. That's the order, Justice Mabinda Pokwana. You asked about that, and you were again met with evasion. The fact of the matter is that that judgment finds that the singing of Dogulipun is hate speech. That, of course, does not mean that a party may not come to court that when I sang it, it was at a school, and it was in a history class, and therefore it was not hate speech. So it falls in the same category as the order that we have in this case. So that deals with topic 1. Was the case properly pleaded, and was the list properly identified? The fact of the matter is that it was. And it's true, Justice Savage, that Section 21, subsection 1 of the Act requires 2 things. The first is that an inquiry must be conducted, and clearly an inquiry was conducted. The second is once an inquiry has been conducted about a specific event, which was what transpired in this case, a declaration or a determination may then be made, and that's what happened in this case. So there's nothing really controversial there. The second question then that has to be answered is, what does this flag mean? And in this regard, the court has had various theoretical postulations about what the flag might mean in the various contexts. But what does it mean historically and contemporaneously in the context in which AfriForum used it at the Black Monday event? We have a fully reasoned judgment in the High Court, which sets out the contemporary uses of the flag and the historical uses of the flag. And perhaps it might be the right time to circulate the pack of sources which the High Court refers to, but they may be difficult to actually source. Yes, we will indeed email it to Justice Plaskett. And what we have included there So, President, what we have included there, you will see, is the old South African Constitution, the 1961 Constitution, the tricameral Constitution of 1983, the debates when the flag was introduced in Parliament in 1926, as well as the debate when the flag was introduced in 1927, when it was finally adopted in 1927. Now, those are significant because they are fully set out in the judgment, because they make it quite clear what the historical meaning of the flag is. So there is no dispute about the historical meaning of the flag. We had initially thought that our learned friends will not enter the debate into the meaning of the flag, and that the meaning would be beyond dispute. But plainly, the meaning is still disputed. It is, in fact, a form of denial speech. It's a form of denialism. So we start with the 1926 introduction of the Nationality and Flag Bill. And the relevant section here would be at page 7 of the document that I have introduced, which is page 4030 of Hansard. And this is the 25th of May, 1926. And the person speaking here is Malan, D.F. Malan, who at the time was the Minister of Interior. The brief context to this is that the National Party has entered into a coalition with the Labour Party, and they have now formed the pact government from 1923, and they have defeated the South African Party of Smuts. And what they are doing is they are introducing a new bill, and it will serve two purposes. The first one is to give white people of Dutch and English origin South African nationality. And we know that what accompanied that in 1927 was the total exclusion of Africans from South African nationality, because they were all regarded as natives under the Native Administration Act. So Malan is telling the world why he is introducing this bill. Now, he then explains, we haven't numbered this, but it's somewhere in the middle, towards the end of that passage on the right-hand column, where he explains why the flag is necessary. He says, a flag is not a mere cloth. A flag symbolizes national existence. A flag is a living thing. It is a repository of national sentiment. A flag is able to create the greatest enthusiasm. A flag is able to move to tears. A flag can stir the deepest springs of action, and it can inspire to the noblest efforts. For a flag, a nation can live, for it can fight and it can die. For that reason, there is nothing in the life of a nation which is so powerful and as unifying factor whenever there are different sections composing that nation as a national flag. Now, in the following page, he explains what those different nations are at 4032 at page 8. And he explains that those nations that would be united by the flag are the Dutch speakers and the English speakers. So he is talking about how to unite white South Africans. But united against who? Will be united against the native populations of the country. So that was the first instance when the flag was introduced in 1926. It was not adopted in that instance because of the resistance by Jan Smuts. It would then come back for a second reading in May 1927. That you will find from page 16 of what I have introduced. And the clearest illustration of what this flag meant would be at page 4009, which is page 25 of the document there. And you will see this, it starts on the left column at the bottom of that page where the Minister of Interior speaks, and the following page where he continues. But basically what he explains is the following. He says, in this flag, the most characteristic feature is the cross, a red cross upon the white cross. In the flags of the world, we often have crosses, and the crosses always stand for the idea of the maintenance and the spread of Christian civilization. That has been so since the days of Constantine the Great, the first Roman emperor, who was converted to Christianity. On the eve of the great battle, which had to be decided whether Christian civilization or barbarism were to triumph, he saw in the skies, so the legend goes, a cross, and that was to him a sign of help and assistance from above and of victory. We find the same in the history of Denmark, when the first Danish king who accepted Christianity was on the eve of the decisive battle. He also saw, as the legend goes, a cross in the skies, and that also was to him a symbol of assistance from above and victory against the forces of barbarism. Then he continues there. That is also the significance of the three crosses in the Union Jack. It is always said that the Union Jack stands for righteousness, peace, and justice. Let it be so. I admit it is so. But why is this so? It is not because it is the flag of England only, But right from the beginning, these crosses have had their significance, and the significance is the maintenance and spread of Christian civilization, and it is Christian civilization that stands for righteousness, peace, and justice. So that's the English part of it. He then continues to the Dutch part. He says, that was the idea, the maintenance and spread of Christian civilization behind the landing in South Africa of the first white settlers of Van Riebeeck and his band. And that ideal was expressed by him on the day he landed in a prayer which is still found in the archives of the Cape. That is the idea which animated the Dutch-speaking people in the Great Trek. That is the great lesson of the Blood River Dingaan's Day, the maintenance and spread of Christian civilization. Then he concludes, therefore I say, if there is anything which is designed to bind the racial elements of this country in one common destiny, and these racial elements are the Dutch speakers and the English speakers, it is the idea which is expressed by the cross on the flag. As far as the backward races are concerned, now the blacks are the backward races, I think that nothing should appeal to them in the flag more than a symbol and guarantee of their upliftment and their protection than the cross. So, this is a celebration of white supremacy. And it's unashamed, and it is explicit, and it stares you in the face. Thank you. So, if it is clear then that the flag symbolizes the arrival of Jan van Riebeeck, it symbolizes the supremacy of the British. Then the question is, and they explicitly say when they introduce it, that the backward races, meaning the black people, must feel proud at their protection and their upliftment. It's clear then that it is a symbol, not just of exclusion, but of domination. Blacks are afforded an inferior status. Whites are presumed superior. And in 1928, we know that the Nationality and the Flag Act is introduced, made into law. Then we also know that in 1948, the National Party becomes the government under Malan, the person who introduced the flag. In 1961, which is at page 2, that symbol is endorsed and incorporated into the flag, into the Constitution, Section 5.1. The national flag of the Republic shall be a flag consisting of 3 horizontal stripes of equal width from top to bottom, orange, white, and blue, on which there shall appear in the center of the white stripe the flag of the Republic, the orange Vrystaat, hanging vertically and spread in full, and on opposite side and adjoining the flag, referred to in paragraph A, the Union Jack as it existed in 1927, horizontally spread in full towards the pole. And then it continues. Then we know that remains page 3 at section 4 of the tricameral parliament, precisely the same clause you find in the 1961 constitution endorsed in the 1983 constitution. And these two always go together, citizenship and the flag, white citizenship and the flag, as symbols of white unity, symbols of white supremacy, but also symbols of domination. So, that historical context is set out in part by Justice Mujapelo, and we've now given the full context to it. That continues until it is changed. The flag goes in 1994. So the question is, what are the contemporary meanings to the flag that are outside of Section 12, outside of the proviso? What are these contemporary meanings to the flag? The only contemporary meaning to the flag that we know, not the fiction that my learned friend was arguing about, the only contemporary meaning to the flag is a yearning for the return of apartheid. It's the rejection of the constitutional system. That's the true use of this flag. That is why when white people organize a protest about farm matters, they don't talk about the criminality of the farm matters. They talk about the return of the old flag. It's the reminder of the world in which they were born. That's the true, real world we live in. Not the fictional stories of black people hosting this flag, a symbol of their own domination, using the dominant meaning. The only person who displayed this flag after the judgment was Ernest Roots. He displayed the flag on Twitter. It's the members of AfriForum who displayed the flag in total contempt of the judgment by Justice Mujapelo. So that's the world in which we live in. So in the contemporary South Africa, the flag continues to represent white domination over black bodies. But it's worse than that, because in 1973, the United Nations declared apartheid to be a crime against humanity. So it's not just an affront to the dignity of Africans, but it is also an affront to people of any race who support humanity, because this is a reminder of the crime of apartheid. My learned friend made reference to the Rome Statute published in 2002, and then he drifted along to communism, etc. This case is not about communism, it's about one flag. It's about the apartheid flag. So the contemporary meaning, I'm afraid, has not changed. It is still the domination of white races over black bodies. It is still a yearning for the return of a past which is gone, this loss of power that members of AfriForum or anyone who displayed the flag felt on Black Monday, because there is no connection between the old flag and the killing of white farmers, which is unjustified. But it continues then this role of being an affront to humanity. So anyone then who continues to display the flag today endorses the crime against humanity, endorses the attack on black dignity, and endorses the superiority of whiteness, because that flag, as Malan told us, was an embodiment, total embodiment of apartheid. So if that is true then, that the historical meaning has not been transformed into the contemporary age, and that the flag still carries this affront to the dignity of Africans as a whole, where did the court go wrong? Because that must be the accepted and dominant meaning of the flag. I know that it's sometimes called dominant meaning, but even if one accepts dominant meaning, where do we go? So we know that we are dealing with a symbol of racism, but also we are dealing with a symbol of the crime against humanity. Under Section 10 of the Equality Act, things like this are regulated by statute. Now, I want to go there. The section, as rewritten by the Constitutional Court, we've cited this at paragraph 37 of our heads of argument. It reads as follows: subject to the proviso in Section 12, no person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to propagate or promote or propagate hatred. And prohibited grounds they obviously include race. And the proviso in Section 12 is the exclusion: artistic creativity, academic and scientific inquiry, fair and accurate reporting. So those are all excluded from the reach of Section 2010. And the Constitutional Court has gone through this first element, harmfulness or incitement to harm. Now, and the adjective harmful means causing or tending to cause harm or injurious. And how is that to be experienced in practice? We know that, we cite this at paragraph 42. We know the two judgments that deal with this. First is the Kumalo judgment by Justice Sutherland, which has been endorsed with approval in the Kwelane judgment. This is how harm may manifest it. Firstly, people outside of the target group may be encouraged by the speech to shun, denigrate, and abuse the target group. So the target group in this case of the display of the South African old flag are black people, but there may also be white people that may be encouraged to shun, denigrate, and abuse the target group. And so that's the first way in which we know that speech or a display causes harm. We've cited this at paragraph 42.1. It's the members of, not of the targeted group, but members of the, I would say, favored group. Then there is an impact on people inside of the target group. What impact will this have on them? And the test is, they will not only experience alienation, isolation, intimidation, and degradation, they will also feel resentment, fear, or want to avoid or even retaliate against the group from which the speaker comes. Imagine the feeling of those black people that were, because there were some black people that were in the Black Monday. Then the third element is harm in general to social cohesion, which may be caused by the reaction of the members of the target group and the reaction of the members who are not in the target group. And they say this, in turn, will undermine the nation-building project, it will undermine the goals of the Constitution. So that is how harm is to be measured. So on point one, plainly, the flag excludes or encourages believers in white supremacy to exclude, deride, shun, denigrate, or abuse members of the target group. Or at the very least, it encourages discrimination against them, or it encourages hostility against them. Number two, it impairs the dignity, the emotional, the psychological well-being, the self-worth, and the sense of acceptance of members of the target group. In other words, it has these effects on African people. It also undermines national unity, because there are many white people that are quite frankly offended by AfriForum and its antics. So in that sense, it undermines national unity, it undermines reconciliation, it undermines social cohesion, all of which are goals in the Constitution. So we say that in paragraph 44, where we conclude that given the meaning that we have given, the historical and the contemporary meaning, the case was clearly, the display was clearly a harmful display. And there is no serious case made that there was no intention, and intention in any event would be irrelevant because the test is an objective one. We make the same point in relation to the second element of Kwelane, the promotion or propagation of hatred. And hatred simply means a feeling of intense dislike or enmity. And we've set this out in paragraph 46, 47, 48. And we've made it clear there that for the reasons we give in paragraph 49, the display of the apartheid flag has those consequences. And then we are left with what exactly that justifies the display of the flag? We are left with private displays, so-called private displays. Now, on private displays, the court will find, firstly, the judgment itself of Justice Mujapele. It dealt with this at paragraph 186. 398. So they dealt with this, this is how the language, and the language is crucial. The question of display of the old flag in private spaces was argued briefly. So again, the language there, it's a display in a private space. And what a private space may be could be a range of things. It could be a school, maybe a private school. It could be a church, that is a private church. It could be a home, that is a private home. But the issue is a display. Then he explains why he finds that a display in a private space should also be covered under the hate speech provision. He says, despite years of apartheid rule, the lives of various races in South Africa have never been compartmentalized. He is right. Apartheid was not about division. It was impossible to divide the country. Apartheid was about subjugation. That was the impracticality that apartheid rule sought, but never achieved. There is therefore hardly any space which is private to the one race to the exclusion of the other, especially in modern-day South Africa. Thus, displaying the old flag in private spaces like homes and schools is equally unacceptably offensive and hurtful, as black people are invariably employed and exposed in other ways to such spaces. So an employer is a private space, but the display of the flag is hurtful to black employees. Then he says the display in such spaces also constitutes hate speech under the Equality Act, as it ostensibly demonstrates an intention to be harmful or incite harm and promote and propagate hatred by propagating to others, including children, that apartheid and how it treated black people was acceptable. If we can focus on children for a moment, if your leadership, if the court finds that so-called private displays are acceptable, and if it accepts the meaning we ascribe to the flag, what this means is that there are certain people in this country that are allowed to raise their children to be racist. But that is completely against the ethos of the Constitution, because the obligation of the courts is to eradicate racism, not to mollycoddle racists. So the Constitution does not envisage a universe in which a parent can raise their child to be racist. It's harmful to the child. Yes.
Crime against humanity. It symbolizes gross violation of dignity.
Yes.
What else is there?
Yes.
Section 12.
Yes. Indeed. And in fact, that does go into the other point about case versus Minister of Safety and Security, which was a case about pornography. Because my learned friend uses case to show that the law does not impact on your private space. But case is about your own consumption of pornography. You can consume pornography, nobody will do anything about it. But you cannot expose a child to pornography, even under case. That's outlawed. And so, if he's going to use case actually is against him. And you may not expose another person to your own pornographic consumption. Yes. 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 Indeed. Yes, indeed. And if the test is met, the Kolana test, then it does not make a difference that there is a display in a private space in a school. There is a teacher who is celebrating white supremacy. Or there is a display in a church. There is a priest who is celebrating white supremacy. If the test is met, in other words, the impact on the target group, then it would still be hate speech. We see this actually in paragraph 116 of the Kolani judgment itself. Yes, in fact, the entire discussion is from 115 to 120. So, firstly, they say words have meaning and effect should be given to them. To communicate assumes the conveyance of ideas. Words in and of themselves are otherwise meaningless, as it was described in Nelson Mandela Foundation Trust, which is this case. What the section targets is thus the meaning behind the words and not simply the words. I'm in agreement with that court's view that the interpretation of the words includes speech, ideas, ideologies, beliefs, meaning, instructions, and so forth, affords this term a sensible and reasonable interpretation that is constitutionally compliant. And then it continues at paragraph 116. Then in the second sentence, that's the point I wanted to make. But communicate in terms of section 10.1 plainly requires that the speaker transmits words to a third party. There must be communication, the transmission of information. So the key is this displayed to a third party? And then the concepts promote and propagate, it goes on about private. Then they say that excludes private conversations. Now, here I must make one point clear. Most hate speech cases have been private conversations. A white person calls a black person a bobeyan, or a white person calls a black person with a K word in a private conversations. It could never have been within the contemplation of the law that those communications, simply because they happen in an outlying area without the glare of the public view, would not be included within the hate speech provisions. In fact, there is a stronger jurisprudential reason why those communications ought to be regulated by hate speech. So private conversations in this context of paragraph 116 ought to be given a narrow interpretation, maybe the self-consumption that was in case, but it could never be given an overly broad construction so that it excludes within its reach these examples of hate speech. The case from the Eastern Cape, Galeba versus Hasselman, case of a magistrate who called the black person a babayan. In those instances, that's precisely the sort of hate speech that section 10.1 targets. So to come back to the principled issue, it's quite plain that if the test in Kolane is met and there is communication to a third party, even if that takes place in a private space, in other words, not in a governmental building or not in an open space, it would be met by section 10. And in any event, paragraph 116, to the extent that it can be read to exclude all private communication, regardless of context, it must be narrowly construed. And if you look at this case, Kolane, that was a report published in a newspaper. It was a public issue. And therefore, these paragraphs, if my learned friends are right, have to be understood as being no more than obiter. The correct state of the law is that there is no principled distinction between communication in a public setting and communication in a private setting if the requirements in the case, in the test of Kolane are met. So, if the meaning is what I have proposed, and if public or private displays have the impact that I have described to the court, what is left of this case then? What is left are these arguments about ripeness, about mootness, but I've shown on the facts that the case was before the court, it was properly pleaded, it was answered by AfriForum to try and justify the continued use of flare. My learned friend, Mr. Trengov, will take the court through the analysis of the statute on this issue about the so-called powers of the Equality Court. I have no further submissions unless my... Thank you. Thank you, Justice. Yes.
Now, you have three civil wrongs. You have the same conduct that constitutes three civil wrongs, i.e. hate speech in this case, harassment, and unfair discrimination.
Yes.
And I was intrigued because the Constitutional Court, if ever there was a case of clear unfair discrimination, it was Polani. Yet the court only made a declaratory order under Section 10.
Yes.
What are your submissions as regards the fact that the same conduct covers all three wrongs? And is it then competent for the court, the equality court, to have one answer from all three and granted an order in terms of all three?
Yes, I can't remember now on Kolane because I ran the case for the Human Rights Commission. I can't remember whether we made submissions on discrimination or whether we confined ourselves to hate speech, but that's the nature of the animal, I guess. On this main question, Justice Skippers, if you look at Section 21(1), this is how it's framed. The Equality Court, before which proceedings are instituted in terms of or under this Act, must hold an inquiry in the prescribed manner and determine whether unfair discrimination, hate speech, or harassment, as the case may be, has taken place as alleged. So it looks like there is no limitation that if all three have taken place, the court can make a determination along those lines. And if you look at after they have held an inquiry, which is Section 21(2), and the orders, the Act simply says they may make an appropriate order in the circumstances. And then there is a range of suggested orders. But their qualification to their powers is appropriateness. So as long as they've made an inquiry, they can decide discrimination, hate speech, harassment, and thereafter anything that is appropriate. So it does not appear that there was anything statutorily inaccurate, but in the way in which Justice Mojapelo dealt with this, in finding that contemporaneously the same conduct produced hate speech, harassment, and discrimination. Yes, I'm told that we must ask for costs. Indeed. Thank you, Justice. I decided I must put it in at the beginning.
Well, they would have to say so specifically. Well, I don't know. We'll see what the taxing master says. You didn't even ask for speak counsel.
No.
That's too greedy. No, they wouldn't be. They definitely wouldn't.
No,